Hello, I'm Steve Teske, retired judge, and this is the Teske Brief. Thank you for joining me. This is episode 5. It's going to be in 2 parts. Uh, so before we begin, let me just make a brief note about why it's in 2 parts. After recording this episode, I realized that the subject matter, particularly the use of synchronized video footage, made it longer than I had intended. So rather than rush the analysis or compress important context, I divided this episode 5 into 2 parts. Now, the episode is titled The New Use of Force Rule. That is correct. So last year, uh, the United States Supreme Court rejected what has been for 30 years the rule that's been applied called the moment of threat. It's now gone. Notwithstanding the fact, though, that there are many commentators right now after the Renee Good shooting, and now there's been another shooting while these episodes are being recorded of Alex Preddy. And again, there are experts who are using the old rule. Don't know why, but they are. But so part one, though, which you're watching now, takes us up to the moment the first shot is fired. And then part two, it steps back and examines what occurred before that moment, an analysis that is now legally significant following the Supreme Court's decision in Barnes versus Felix. In other words, the old rule, moment of threat, the jury would never have been able to see any of the events that led up to it. But now, with the totality of circumstances rule that the Supreme Court has adopted and unanimously, well, there you go. Now that could change things depending upon the circumstances. Now, with that in mind, let's begin. So let's pause for a moment and separate myth from law. That's what we do here on the Teske Brief. The myth is this: Barnes versus Felix was just another routine police shooting case about video evidence and split-second decisions. No. Here's the law. Barnes versus Felix was about much more than a single shooting. It was about the growing concern shared by judges, scholars, and practitioners across the ideological spectrum that qualified immunity has drifted too far from its constitutional and statutory roots. Now, when Barnes reached the Supreme Court, the justices were presented with a very familiar question on the surface. And it's this: how should courts evaluate police shootings under the Fourth Amendment? But underneath that question was a much deeper one. Has the moment of threat doctrine, it's now the old doctrine, become a backdoor expansion of qualified immunity? Amicus briefs in Barnes made that concern explicit. And for those who are not familiar with amicus briefs, those are what we call friends of the court brief. In other words, they're not parties to the case. They're not going to be going in front of the Supreme Court making oral arguments. These are entities and individuals who are interested in wanting to contribute, and so they can file briefs with the law and argument based upon the law and how they believe it should be applied, trying to influence the Supreme Court. Now, groups as ideologically diverse as the Cato Institute, for example, civil rights organizations, and policing reform advocates argue that qualified immunity is not grounded in the text of Section 1983, and that's correct. You will not see qualified immunity in the actual congressional language, the bill, what is now the law, called Section 1983, and that it was judicially created instead, not legislatively enacted, and that makes a difference, they say. They reminded the court that when Congress passed the Civil Rights Act of 1871, right after the Civil War, it said nothing about immunity. Now, the statute simply created liability for officials who violate constitutional rights. And several amici urged the court to think about police misconduct the way we think about ordinary tort law. And when I say ordinary tort law, I'm talking about like the negligence cases. The most common we see on billboards and on TV are the personal injury lawyers. When you get into automobile accidents and someone's at fault, or there's a dispute as to someone's at fault. Anyway, that's tort law. Now, in a personal injury case, the question is straightforward. Was the defendant's conduct reasonable under the circumstances, and did it cause foreseeable harm? But qualified immunity added a second and much harder hurdle. And it's this question: was there a prior case with nearly identical facts that clearly established the exact conduct as unconstitutional? Okay. Critics argued that this requirement creates a cycle of impunity where courts dismiss cases without reaching the merits, so the law never becomes clearly established in the first place. That was the irony of it. Now, during oral argument in the Barnes versus Felix case, that frustration was palpable. It came through. The justices repeatedly questioned the lawyers in front of them whether the moment of threat rule was allowing courts to ignore how encounters were created, focusing only on the last second or two while disregarding reckless or unreasonable conduct that made violence inevitable. In other words, before that moment of threat, what was going on? And was there anything going on, particularly regarding the conduct of the officer, that could have contributed to the need to use force? So, in other words, the concern was that qualified immunity had swallowed the Fourth Amendment reasonableness. But here's the key point. The court was not prepared to overrule Pearson versus Ray. Now, that's the 1967 decision that gave us qualified immunity. Doing that would require either a direct reversal of precedent by the Supreme Court or an act of Congress. And the court just wasn't ready to take that step of this complete reversal of precedent. So instead, it chose what I call a middle path. Let's pause again and separate myth from law. So the myth is this: Barnes versus Felix left qualified immunity untouched. But here's the law, because that's not true. While Barnes didn't abolish qualified immunity, Barnes significantly narrowed how it operates by rejecting the moment of threat doctrine and requiring courts to consider the totality of the circumstances. Now, that choice matters, and particularly now that we're dealing with what's going on in Minneapolis with the Renee Good shooting, which we're dealing in this series of episodes, and then the upcoming Alex Pretty episodes. Now, by requiring courts and juries to look at the entire sequence of events, the Supreme Court made it harder for officers to claim immunity when their own pre-seizure conduct, that is, right before the moment of threat, for example, their positioning, any escalation, failure to de-escalate when they had a chance to de-escalate, okay, created the danger that later justified deadly force. Now, that shift moves Fourth Amendment analysis closer to ordinary reasonableness and closer to how juries evaluate conduct and negligence in personal injury cases. I mean, it's not identical, but it's closer to that. So applying Barnes versus Felix to the Renee Good shooting, let's take a look at that. How would that work, okay? To illustrate why Barnes versus Felix matters beyond just doctrinal labels, let's walk through how the Supreme Court shift from a narrow moment of threat approach to a totality of the circumstances analysis applies when you have synchronized video like we have, okay, and a series of decisions leading up that show a series of decisions leading up to the use of force. Now, I just want to stop here and tell you that's another reason why I want to divide part one and part two. I want part one to focus only on the moment of threat. In other words, if Barnes versus Felix had not been decided and these shootings up in Minneapolis were taking place, how would the jury apply it in a moment of threat rule? That is, only looking at what happened from the moment the officer reasonably felt fear for his life and safety. So under this old moment of threat rule, courts would often stop at that final instant, as I've been saying, before the trigger was pulled, the freezing time, and asking only whether, in that split second, the officer reasonably feared serious harm. Barnes had rejected that approach and held that courts and juries must consider all relevant circumstances. And mind you, it was a 9-0 unanimous decision, which is you don't see common these days. Okay, but it also included what the officer did and knew leading up to the decisive moment. Okay, whereas with the moment of threat, it doesn't. Now, one of the reasons Barnes was a turning point was the factual sequence that preceded the shooting. So let's just talk real quickly about what happened in Barnes, and I think that might help connect the dots. In the Barnes case, the officer did not fire in response to some sudden, unavoidable threat that materialized out of nowhere. Instead, the officer made an earlier tactical choice, okay, to climb onto the door sill of a moving vehicle, okay? But that decision was not the moment of threat itself. It was a pre-seizure action that increased the risk of serious harm and directly shaped the circumstances the officer later confronted. In short, what had happened is that dispatch had put out a call that there was a car that had unpaid toll fees. And Officer Felix saw this car, pulled it over, walks up, and the short of it is that he was trying to get the license and registration from the gentleman in the car, who's Mr. Barnes. And he said it was in the trunk in a bag, and the officer told him that he needed him to get out. But that's when Barnes didn't get out, and Barnes took off. Well, at that moment, the officer decided to unholster his gun, and he jumped on the door sill. Okay, now think about it. Imagine this: the door sill is like right there at the seat. You step up on it. Now your head is above the roof line of the car, and you're holding on. Probably you would have to be holding on because there's nothing unless there was a luggage rack up there. You would have to be holding on underneath with one hand, with the car moving and probably starting to go faster, and the other hand with a gun. And I think at some moment he probably realized, uh-oh, what did I just do? I just put myself in danger. So with that, and fearing for his own safety, he took the gun, pointed it into, he couldn't see Barnes, but he pointed into where the passenger, because he was standing next to the passenger, and he pulled the trigger, 2 shots. Barnes ended up dead. Okay. So all of that context matters. For example, here's the thing to factor in. This was not a violent felony stop, right? Or even a felony stop. Barnes was suspected, as I said, of driving a vehicle associated with unpaid toll violations. Conduct that standing alone would not result in jail time. In other words, what I'm saying, he ended up dead over a matter that he wouldn't even gone to jail for. Barnes should not have driven away. Okay, I mean, I get that. We all get that. That much is clear. Okay, but the constitutional question is not whether Barnes acted improperly. It's not how this works. The question is whether the officer's response was objectively reasonable in light of the entire encounter. And that is where Barnes changed the analysis, going from the moment of threat, we're not going to use that anymore. And because of that, Supreme Court says, I'm sending this case back down to be tried again using the new rule of totality of the circumstances. So the Supreme Court made clear that courts may now consider whether an officer's earlier decisions unnecessarily escalated the encounter or created the very danger that later justified force or deadly force. In Barnes, the safer alternative may be disengaging, returning to the patrol vehicle, requesting backup, pursuing the suspect was available. Okay. I mean, these are all things for the jury to consider. Instead, the officer chose a course that placed himself in immediate peril over a nonviolent offense. That choice matters under the Fourth Amendment, okay? Some will argue that Barnes should not have driven off, as I said, and that his actions set everything in motion. But I got to come back to this because there are going to be people who are going to be stuck on, well, Barnes, if he hadn't have driven off, none of this would have happened, okay? And that's true, okay? But officers still have a responsibility to act reasonably. The law does not measure reasonableness by blame alone. It measures it by judgment, by whether a reasonable officer properly trained would have chosen the same course of action under those circumstances. This is precisely why the Supreme Court rejected the freeze frame approach. When courts focus only on the final seconds, they risk excusing tactics that unnecessarily convert routine encounters into lethal ones. And this concern is not abstract. When law enforcement leadership communicates a posture of confrontation rather than restraint, language that suggests officers should respond aggressively to even minimal resistance, it can undermine training that emphasizes de-escalation and proportionality. Policy directives matter, tone matters, and they matter most before an encounter turns deadly. And I bring that out because there are things beginning to come out as we move forward after the Renee Good shooting, the Alex Preddy shooting, regarding directives given by Bovino, who was formerly the commander at large, to the ICE agents, okay? Some of it caught on video regarding suggestive aggressive tactics that could work against and override what the ICE policies exist, which I have read some of them about around use of force, which emphasizes de-escalation before using force if you have the opportunity to do it. So the lesson of Barnes is pretty straightforward. We cannot understand the constitutionality of force by isolating the final second. We must examine the full sequence of decisions that led there. That is what the Fourth Amendment now requires. If Renee Good's case goes forward or Alex Preddy's case goes forward, whether in a civil liability suit or for prosecution, it will not be the moment of threat rule. It will be the totality of circumstances test. With all this said, the bottom line is that we cannot get the full picture by isolating only the last seconds. We must see all that led up to that moment of threat. Let's consider how that principle applies to the Minneapolis shooting of Renee Good, not to determine fault, but to explain how the analysis itself must be structured under Barnes. So video compiled and synchronized by multiple sources, including the New York Times, gives us a fuller sequence of events that can be examined as a whole rather than a freeze frame. So let's take another look at those synchronized videos, because what they show, and just as importantly, what they don't show, illustrates why the totality of circumstances rule matters. Remember, under the old moment of threat doctrine, a jury would be permitted to focus only on that final instant before the officer fired. Under Barnes versus Felix, the jury, however, must be allowed, and a court must require consideration of everything that led up to that moment. Now let's take a look at the moment of threat, the part the jury would see had this event occurred before July 2025, when Barnes was decided. So keep in mind, I'm going to show the clip now. It's going to be really short, okay? Because remember, this was the moment of threat. For 30 years, or almost 30 years, this is the only thing juries got to see was the moment of threat, which is always going to be a second or two before the force is used. So take a look.
Same time, the agent filming crosses toward the left of the vehicle and grabs his gun. He opens fire on the motorist and continues.
Okay, so there it is, the moment of threat in this case. That's what juries would be seeing if Barnes versus Felix had not been decided last year and was still the law. So, what you just saw, ending with the first shot fired into Renee Good's car, marks the conclusion of part one of this episode. So remember what I said, I've intentionally divided this episode into two parts to respect your time and to keep the analysis clear and focused. The full episode runs longer than usual because it uses synchronized video evidence to explain a significant shift in constitutional law, and I didn't want that explanation to get lost or rushed. But there's a deeper reason for this pause, ladies and gentlemen. If this shooting had occurred before the Supreme Court decided Barnes versus Felix, this is all a jury would have been allowed to see. Just this moment, just this frame, just the instant when the officer claims his life was threatened. Under the old moment of threat rule, courts routinely froze the analysis right here at the final second and asked only one question: was the officer afraid in that moment? Everything that happened before this point, the officer's movement, positioning, tone, opportunities to disengage, choices that escalated or de-escalate the encounter was often treated as legally irrelevant. And that narrow lens has mattered. It has shaped outcomes, it has shaped verdicts, and it has shaped public understanding. In part 2 of this episode, we begin before this moment. We're going to rewind. We're going to go back before the shooting. We're going to look at the synchronized video footage compiled by multiple sources, showing what occurred leading up to the shooting, footage that courts and juries are now required to consider because the Supreme Court rejected the moment of threat doctrine in Barnes versus Felix. And then in part 2, you'll see how expanding the lens changes the analysis, not to assign blame, but to understand how constitutional reasonableness is now evaluated under the totality of the circumstances. While everyone else, some lawyers, many law enforcement, probably have testified as experts in court, are saying they are assigning blame. They are saying whether it's self-defense or it's not self-defense or if it was actually a good shoot. I'm not going to do that. I'm just here to separate myth from the law. I focus on the law, okay? And that's all I'm doing here. Whatever y'all may think, that's different. Whatever I may think, I'm going to keep it to myself, other than what the law says, which is the truth because it's in black and white. Now, you'll see how easy it is under the old rule to miss the larger picture, and how that narrow view has historically tilted outcomes by showing only the moment the fear crystallized, not the sequence of decisions that led there. That's the difference Barnes makes. So if you're watching this on YouTube, part 2 is available now. And I encourage you to continue because the Constitution doesn't operate in freeze frames as we're learning now. And after Barnes versus Felix, neither do the courts. So I'll see you on part 2. Take care.